The courtroom is a battleground of truth. Evidence is the weapon and cross-examination is the strategy. This is where the skills of a lawyer are put to the ultimate test as they navigate through the intricate web of facts and testimonies. In this high-stakes arena, every word matters. Each statement, each pause, and each gesture can tip the scales of justice. It is within the crucible of cross-examination that the veracity of witness testimony is tested. The pressure is immense, and the stakes are tahqiq. The Qanun-e-Shahadat Order, 1984, serves as the guiding principle in this legal battle, ensuring fairness and justice prevail. This legal framework is the backbone of courtroom proceedings in many jurisdictions. Cross-examination, a cornerstone of legal proceedings, empowers opposing counsel to challenge a witness's testimony. It is a dynamic process that can make or break a case. It is an opportunity to uncover inconsistencies, expose biases, and ultimately reveal the truth. The lawyer's role is to meticulously dissect the witness's statements, looking for any cracks in their story. This process is crucial to a fair trial, as it prevents one-sided narratives from hijacking justice. The judge plays a pivotal role in ensuring that the cross-examination remains fair and just. The Qanun-e-Shahadat Order, 1984, particularly Article 133 Paisals, plays a pivotal role in this process. This article lays down the rules for how voluntary statements should be treated during cross-examination. This article specifically addresses voluntary statements made by witnesses during cross-examination. These statements can be spontaneous and often reveal more than what is asked. These statements, while seemingly innocuous, can have profound implications on the outcome of a case. They can sway the jury, influence the judge, and ultimately determine the verdict. Understanding the nuances of Article 133 is essential for both legal practitioners and those seeking justice. It is a critical piece of the legal puzzle that can significantly impact the direction of a trial. It is within the framework of this article that we delve into the complexities of voluntary statements and their impact on legal proceedings. The courtroom is not just a danki adafi place or of Bantus's Biampi of judgment, but how can this say for a theater where the truth is unveiled one statement at a time? Article 133 of the Qanun-e-Shahadat Order 1984 deals specifically with statements made by witnesses that go beyond the scope of the questions asked during cross-examination. These voluntary statements, often referred to as statements not relevant to the matter in question, can significantly impact a case. The article aims to prevent witnesses from introducing irrelevant or prejudicial information into the proceedings. It ensures that the focus remains on the specific issues at hand, preventing the jury or judge from being swayed by extraneous details. However, the interpretation and application of Article 133 can be complex. Determining what constitutes a voluntary statement and its relevance to the case requires careful consideration. Judges play a crucial role in assessing the admissibility of such statements, ensuring they do not unfairly prejudice the outcome. The article's emphasis on relevance underscores the importance of focused questioning during cross-examination. It highlights the need for legal counsel to carefully craft their questions, avoiding open-ended inquiries that could lead to tangential responses. Voluntary statements, while seemingly innocuous, can be a double-edged sword in legal battles. On the one hand, they can inadvertently reveal crucial information that strengthens a case. On the other hand, they can derail proceedings by introducing irrelevant or prejudicial details. The danger lies in their unpredictability. Unlike carefully crafted responses to direct questions, voluntary statements emerge spontaneously, often driven by a witness's emotions or personal biases. This unpredictability makes them a wild card in the courtroom, capable of swaying the jury's perception in unforeseen ways. Furthermore, voluntary statements can raise questions about a witness's credibility. When a witness volunteers beyond the scope of the question, it can be perceived as an attempt to influence the proceedings or bolster a particular narrative. Understanding the potential impact of voluntary statements is crucial for both legal teams. It highlights the importance of thorough witness preparation, emphasizing the need to stick to the facts and avoid offering unsolicited information. Section 4, Case Law Insights, examining PLD 2024 Sindh 289 and 2003 YLR 406. Case law provides valuable insights into how courts interpret and apply Article 133 of the Pakistani legal framework. Two key judgments, PLD 2024 Sindh 289 and 2003 YLR 406, offer compelling examples of how voluntary statements have been addressed in Pakistani courts over the years. In PLD 2024 Sindh 289, the court emphasized the importance of context when evaluating voluntary statements. It ruled that statements made by a witness, although not directly related to the question asked, could be admissible if they provided crucial background information or clarified ambiguous points. This judgment underscored the court's willingness to consider the broader narrative and context in which a statement was made. Conversely, in 2003 YLR 406, the court took a stricter approach. It held that voluntary statements made by a witness during cross-examination, which introduced new and unsubstantiated allegations, were inadmissible. The court emphasized the need to protect the accused from unfair prejudice. These contrasting judgments highlight the nuanced nature of Article 133. They demonstrate that the admissibility of voluntary statements depends on various factors, including their relevance, context, and potential for prejudice. The court's approach in these cases shows a balance between allowing relevant information and protecting the rights of the accused. Understanding these judgments is crucial for legal practitioners as they navigate the complexities of Article 133. These cases serve as a guide for how voluntary statements should be treated in future legal proceedings. They provide a framework for evaluating the admissibility of such statements, ensuring that justice is served while safeguarding the rights of all parties involved. Section 5, Practical Implications, or glimpse into courtroom dynamics. To truly grasp the impact of Article 133, let's step into a hypothetical courtroom scenario. This will help us understand the practical implications of legal proceedings and how courtroom dynamics play out in real time. Imagine a witness being cross-examined in a theft case. The atmosphere is tense, and every word spoken can significantly influence the outcome of the trial. The defense attorney asks, "Mr. Smith, did you see my client, Mr. Jones, leave the store with the stolen merchandise?" This question is direct and aims to establish a clear fact. Mr. Smith responds, "No, I didn't see him leave with anything." His response seems straightforward, but the dynamics of the courtroom are about to shift. "But I heard he had a gambling problem and needed money." This unexpected statement introduces new information that wasn't solicited by the question. In this example, Mr. Smith's statement about Mr. Jones's alleged gambling problem is a clear example of a voluntary statement. Such statements can catch everyone off guard and change the direction of the trial. It goes beyond the scope of the question and introduces potentially prejudicial information about the defendant's character. This can be highly problematic in maintaining a fair trial. The defense attorney would likely object to this statement, citing Article 133. This article is crucial in ensuring that only relevant information is considered. The judge would then have to decide whether the statement is relevant to the case or if it should be struck from the record. This decision can have significant implications for the trial's outcome. This scenario illustrates the challenges posed by voluntary statements. They can disrupt the flow of questioning, introduce irrelevant information, and potentially prejudice the jury. They can disrupt the flow of questioning, introduce irrelevant information, and potentially prejudice the jury. The jury's perception can be swayed by such statements, making it harder to ensure a fair trial. Understanding these dynamics is essential for anyone involved in the legal process, from attorneys to jurors, to ensure justice is served